Hi, good afternoon, everyone. I'm Alicia Field. I'm the Director of Events for the Greater Reston Chamber of Commerce, and I'd like to welcome you to today's Business Success webinar, Understanding Your Leases and Contracts in the COVID-19 Landscape. So before we get started, I'd like to quickly recognize our annual sponsors, and I'm actually just, wait for me one second, please, while I share my screen here. All right, there we go. Thank you for your patience. All right, so you can see here our strategic sponsors. We also have our visionary sponsors. And lastly, we've got our advocate sponsors. So thank you to all of them for doing so much to support the Chamber throughout the year. Also, before we get started, just a few housekeeping notes for today's webinar. You can certainly feel free to put your comments in the chat box, which you'll see on the right. However, please do not put any questions there. We'll try to keep up with any comments and perhaps comment on those throughout. But otherwise, if you do have a question, please put it in the Q&A box. And then certainly once we get through the presentation, we'll get to as many questions as possible as we can at the end. So thank you for doing that. Otherwise, let's see, wanted to let you know that this webinar is being recorded and we will have it available on the Reston Chamber's YouTube page afterwards. We'll also send you a link to that so you can certainly reference it afterwards and share it with anyone who couldn't be able to join us today. Well, now on to the stars of our show. We're more than pleased to have our legal experts here, Bob Hicks and John Kelly from Bean, Kinney Korman, and they're here to help us navigate the force majeure clauses in our leases and contracts. Definitely very timely, very interesting. So we're so pleased to have you here today, gentlemen. Thank you all again for joining us. Please take it away, Bob and John.
Thank you. Thank you for having us. As Alicia said, my name is Bob Hicks. I'm a shareholder at Bean, Kinney Korman. I focus mostly on commercial litigation with a specialty in complex real estate litigation, contract litigation. My partner, John Kelly, is a corporate transactional partner and has a concentration in commercial real estate and commercial leasing. So we figured between the two of us, we've pretty much got this universe covered. We're obviously living in quite literally unprecedented times. I'm 50 years old and never in my lifetime has anything happened like this. And I guess unless you were over 100 and remember the Spanish flu epidemic, no one here has lived through something like this. We saw just this week, the unemployment claims, initial claims of over 3 million in a single week, which broke the record by 5 times. We're living in incredibly chaotic economic times and health times. Personally, my brother owns 2 restaurants, one in Vienna and one in Ashburn. Like many businesses, he's been closed down. His revenues have fallen off 95%. It enforces a lot of questions. One of the things, the principal thing we're going to talk about is force majeure language in contracts and in leases. Then we're also going to talk about briefly business interruption insurance, and then also briefly a little bit about what we know banks and other professionals are doing in response to this. And we have some good timely information. Sorry, go ahead, John.
I would add that we understand that our audience today is made up of folks from all different industries. We probably have owners and investors of commercial property. We probably have tenants, maybe office tenants and retail tenants. Perhaps we have banks. So this pandemic is a crisis for the entire global economy. Obviously, it's a health crisis, but it's also an economic crisis. So we're going to try to give a brief overview of how it's affecting, all the various folks who would have an interest in a commercial real estate or a commercial contract scenario. We're not going to get too much into residential type leases. That's really a whole separate animal, but if you have any questions there, we're happy to entertain. But as Bob was saying, we're going to try to focus mostly on force majeure. And as we get into, that's a clause in most contracts and most leases. But in times like this that are so almost unprecedented, sometimes you really have to look outside the four corners of the language and of the agreement and try to use creative arguments for your clients. And that's what we'll get into. And perhaps trade a few war stories that we've heard over the last few weeks.
Thanks, John. So the first slide, literally, for fun, force majeure, it's a French word, which is interesting that it appears in our English common law heritage, means superior force. I put the definition from Black's Law Dictionary. It's an event or an effect that can be neither anticipated nor controlled, which certainly describes what's going on with COVID-19. They're often in contracts, as John said, in commercial leases and on other commercial contracts for delivery of goods and services, event planning, things like that. Typically we think of force majeure events as wars, revolutions, riots, national labor strike, and certain quote unquote acts of God. Next slide, please. So I included, force majeure is a creature of contract. So thus the clauses are very, very fact specific. So, all of the participants here who probably have, commercial leases or other contracts, it's going to be different for everyone. So you have to first look very carefully at the language in your individual contract that you're concerned about, and get a definition for what force majeure is. I put a sample clause there in the bottom right from a contract that I had. Neither party is responsible for any failure to perform its obligations under this contract if it is prevented or delayed in performing those obligations by an event of force majeure. Sounds great, but what does that really mean? Next slide.
And I'll just add to that for a moment about the definition in these clauses. Bob and I have worked on hundreds of contracts. I've negotiated hundreds and hundreds of commercial leases, and rarely is this clause even negotiated. If I'm doing a tenant deal of over 100,000 square feet, every clause is negotiated, and maybe you're going to really fine tune what event is a force majeure event, what obligations of the tenant are forgiven, excused, and what kind of notice do you have to give to either party to set that clock ticking. Sometimes it's that kind of detail, but normally parties don't negotiate force majeure clause. It's considered boilerplate. It's one of those clauses at the back of the lease in the miscellaneous section that even commercial real estate lawyers, we're going to look at it, but it's really normally not considered something that is worth the legal time or the brain time to go over. Now you get these circumstances where you're like, darn, I wish I had paid more attention to this language. But normally we don't even give it hardly a second thought.
So the bottom, this is from the same contract, the bottom bullet point, what does force majeure mean? What is the definition? And this contract provided that it shall mean a circumstance which is beyond the control without the fault or negligence of the party affected, in which exercise of reasonable diligence the party was affected was unable to prevent, provided that the event circumstance is limited to the following. And then this is what is it? Next slide. And this defines it. This was from the same clause as you can see. A was riot, war, invasion, acts of foreign enemies like terrorism, civil war, rebellion. B, acts of God, including earthquakes, flood, fire, and other physical natural disasters. And C, strikes at a national level. Well, obviously, COVID-19 doesn't fit into A and C very well. In terms of these clauses, acts of God is a very common term included in these force majeure contracts. We tend to think of acts of God generally being natural disasters like earthquakes and massive fires, hurricanes. The question when COVID-19 first came on the radar was, could this pandemic be considered an act of God under Virginia law? Next slide. Exactly. So, it'd be nice, obviously if you go and review your force majeure clauses, it'd be great if there was, language in there that defined force majeure as a pandemic declared by the World Health Organization or the CDC. Probably doesn't, but certainly it makes your life a lot easier if it does. So then, look and see if there's an act of God or other generic term. And again, so what does act of God mean? Is it weather events? So it's limited to hurricanes and earthquakes? Or can it in fact include a pandemic like COVID-19? Next slide. Act of God in Virginia law goes back a long time. For the people that are wonky or any legally trained folks on, I provided some case authority, and I'm not going to go super in depth on all of this, but this is a case from the 19th century, pre-Civil War in Virginia, that defined act of God as those losses that are occasioned exclusively by violence of nature, by the kind of force and of the elements which human ability could not have foreseen or prevented, such as lightning, tornadoes, sudden squalls of wind. So does that mean it's only limited to extreme weather events? That doesn't answer the question. Next slide, please. The court in that case, the Friends Court, this is 1849, goes on to talk about it can't be done with what really we think of in torts as contributory negligence. And it gives the specific example that, hey, water could be high, and if you're a captain, if you hit a hidden rock, that's human intervention. That's not going to be an act of God. So there are limits. Next slide, please. It goes on to answer the question of can COVID-19, later we see this 1926 case, again, a Supreme Court of Virginia case, that says, whether an extraordinary flood is an act of God is a mixed question of law and fact. What does that mean practically? That means the jury or the trier of fact is going to decide ultimately whether something fits under an act of God, which is probably good if you're seeking to enforce it, because I think quite likely there's going to be a lot of sympathy for people that were affected by COVID-19, forced to shut down, for example. It still does not clearly define the parameters of violent nature, but it comes later. Next slide.
Let me interrupt, Bob, 1 second. I see a question, which is a great question, where someone asks if government shutdown is defined as force majeure. Is it or is not? Well, the answer is you've got to read your clause. It's amazing how different these force majeure clauses are. I have a client with, 50 or so locations across the country. And one of the projects we're working on now is looking at the force majeure clause in each of these various leases. And some of them have pandemic, some of them have government shutdown, some of them don't. Most of them do not. Normally the things you negotiate in a force majeure clause are things like failure to obtain government permits, failure to obtain building permits that are for reasons outside your control. For example, you can't find labor, you can't find supplies. Again, as we'll get into later when we get into the lease and contract specific guidance, it is critical that you closely review the language in your agreement and then determine the circumstances of how this pandemic has affected your business or your property. Can tenants operate, or are they prohibited by order of law? Or are they prohibited because of guidance from the CDC? But to answer your question, it depends.
Thanks. And so this case also pointed out that the act must be unusual or unprecedented. And what they're really getting at is, you can imagine those of us who've ever been to Old Town Alexandria, that floods all the time, right? So if it floods and a business is closed in Old Town by the river, is that going to be unusual or unprecedented? And that's going to be a mixed fact for the jury to decide. There are everyday floods and there's the proverbial 100-year flood, right? Next slide. And this goes on to say, later we get to 1931, the Supreme Court of Virginia, again, sort of providing slowly more and more clarity, says that, it doesn't have to be unprecedented, that, unusual is sufficient. And it gives the court gave a specific example of, a building destroyed by an earthquake would be an act of God. And should the building be rebuilt and there's another earthquake, it would still be an act of God, and it doesn't change the fact that there was a first earthquake. Unprecedented, unusual doesn't mean, has to be unprecedented. Next slide. What's interesting next is, we get into a little bit later, now we're into the 50s, the court talks about free from negligence to assert act of God. And we think about negligence as a tort claim. When you're negligent, you don't think about it in terms of contract usually. But in fact, they've almost set up a contributory negligence standard that if you contributed to the negligence, you didn't do something, and you can imagine a myriad of ways this may come up in a COVID-19 situation where maybe the other side would allege you were negligent in something by doing something, allowing it to affect, versus a situation where the government closed you down, said you can't operate. Well, it's going to be much harder for the other side to argue that you were contributory negligent when the government said close down. And the parenthetical at the end, the example in this case was it was against the city of Portsmouth, where they had allowed an unfinished earthen dam to remain, and there were bushes and weeds, and it burst, and there was a problem during an unprecedented flood. And the ruling was, well, that was contributory negligent because you'd allowed this dam to sit there kind of unfinished for a long time. Next slide. Now we get into more, contemporary interpretations, and the act of God is actually tweaked by the modern court. The language is subtle, but it's importantly different. That is, defining act of God as such an unusual and extraordinary manifestation of the forces of nature. Forces of nature, and I underlined it, that it could not be expected under normal conditions and anticipated or expected. And whether active, repeated some of the earlier language. So, forces of nature gets into something beyond just sort of weather events or extreme weather. And again, excluding any acts of human agency, negligence. So, more helpful language for the argument that COVID-19 is would be covered under an act of God. Next slide. Lastly, I think it's very important, this is the most recent case on act of God in the Supreme Court of Virginia, is that the injury must be the sole and proximate cause of the injury. Meaning, for example, if you were already failing to pay rent and your business was struggling, and then this was sort of the straw that broke the camel's back, you may have a hard time arguing act of God because it wasn't the sole and proximate cause of your injury. Versus a business who was running fine, everything's going swimmingly, and then all of a sudden the government forces you to close, I think you have a much stronger argument that it was a sole and proximate cause of your injury. Next slide. So the interesting question is, I know early on, to those who read, was COVID-19 natural or man-made? And given what we just read about, forces of nature, that could be very important of whether the virus was man-made, which would be, if someone made it in a laboratory and it escaped and it was negligence by, this country or another country, would be very different than if it naturally occurring. And so I included, and I don't mean this to be authoritative, and this is not my specialty, the law is, but I cited 2 articles that had come out in the last few days that from scientists, and the studies are showing that it's a man-made, not a lab-engineered virus. So that would help make the argument that it's a natural occurring or a force of nature versus someone else's negligence, man-made. Next slide. So where does that leave us? Is there a definitive answer? And quite simply, the answer is no, it was not a definitive answer. I could not find a Virginia published case that talked about pandemics and acts of God or force majeure specifically. I think my argument would be you certainly would have a very colorful claim with an act of God clause to say, especially if you were a business that, hey, the governor issued an executive order and said, shut down your restaurant, your retail location, what have you, no more than 10 people. Everything was going well. So you kind of tick off the things we just talked about. Certainly COVID-19 is a highly unusual act of nature, right? It's, we haven't seen anything like this probably ever, or certainly since the Spanish flu 100 years ago. The fact that there has been other pandemics in our history, the Spanish flu, that's in control. So that's not going to defeat the claim. Active care. This is not a situation like the case we read from the 19th century where the captain on the river, could have done things to avoid the hidden rocks and shoals under the water. For the most of us here, there's nothing that could have been done. The government said close down one day and we had to close down. So I think the contributory negligence part of it is going to be favorable. And then lastly, it has to be a determination about the sole and proximate cause of your damage. And that's going to be very fact specific in terms of, what was going on with your individual business before this all happened. Certainly you can see the other side would be keen to argue that there were other contributory factors and it wasn't the sole and proximate cause. Next slide. and I'll let John weigh in on some of the commercial lease aspects of this.
Sure. And Bob, jump in whenever you have anything to add, please. Yeah, as I was mentioning earlier, almost all leases have a force majeure clause. Like I said, normally it's buried somewhere in the back. We call that boilerplate. It's not normally heavily negotiated. You've got to read the language. Some of them include pandemics. Some of them include government shutdowns. Some of them are more short and kind of use that act of God language that Bob was mentioning earlier. But one thing that you have to realize is most leases are landlord friendly. So even though there is a force majeure clause, and even though this might qualify or should qualify, often these clauses say that one of the obligations that tenant is excluded from is not the payment of rent. Rent is typically carved out of the things that are excused from force majeure, which really is a problem if you're relying on the force majeure clause in this instance. But not all. Again, I've been looking through a ton of force majeure clauses recently, and some of them are not clear as to whether rent is excluded or not. And as we're going to get into later, that's if you're a tenant, that's an argument you'd have to overcome. If you're a landlord, that's an argument you want to try to prevail on. But there's some extraordinary circumstances here that arguably could trump that language in the force majeure clause. Next slide.
So, John, this is actually very topical because we had a question from Gwen that said, her lease doesn't have a force majeure clause. Are there other areas of the law that may be applicable? And so this is answering the question.
Yeah. So for leases that don't have the clause, and even if they do, again, I don't want to get the landlords on this call mad at me. I certainly represent both landlords and tenants all the time. But, there's going to be a ton of litigation over this unless the government issues clear authority. And who knows, right? This is moving so fast, it's changing day by day, hour by hour. But for leases that don't have a force majeure clause, and even if they do sometimes, depending on the circumstances, another defense tenants might want to consider is this old common law thing called the doctrine of impossibility. This is a situation where the use you're allowed to use this space for is impossible. The only permitted use language in that lease says you are a tavern open to the public, and the governor says, nope, you can't be a tavern open to the public. So that's, it's impossible to use the premises for the only foreseeable purpose. Next slide. The doctrine of impossibility is one of these old common law things that we inherited from England. Each state has their own nuanced language. There's a related doctrine called frustration of purpose. I think in this case, well, frustration of purpose could maybe come in if you're only allowed to work very limited hours, arguably. The doctrine of possibility seems to be more relevant in this situation. So the party relying on that defense, in this case, the tenant, would have to establish that one, the unexpected occurrence of an intervening act, that seems to be clear. Two, such occurrence was of such a character that its non-occurrence was a basic assumption of the agreement of the parties. If you sign a 10-year lease to operate a restaurant, you may be able to foresee earthquakes or hurricanes, but this seems to be beyond the pale. But again, as we litigate this, there's going to be a lot of articles showing people predicted pandemics in 2006, what have you. This is going to be very fact specific as it unfolds. Three, that the occurrence made performance impractical. A critical factor is whether the party agreed in the lease to assume the risk of performance, whether possible or not. That sort of alludes to the force majeure clause. So if you have the force majeure clause as a general rule in Virginia and all states, if you have a commercial agreement you have a commercial lease, the judge is going to think, well, both parties are business persons, both parties are sophisticated, both parties have the benefit of counsel, so the language in the force majeure should control. So that's the starting point. So what we're going to see here is whether or not these circumstances are so extraordinary that they can rise above the language in that agreement. Generally speaking, and you know, Bob goes to court every day. He can jump in on this with his opinion, but generally speaking, judges are sympathetic to these sort of circumstances, especially a smaller tenant that maybe didn't have a ton of legal resources to negotiate the lease very heavily. If they are shut down by the governor for 3 months, hemorrhaging their business, are they going to enforce a landlord drafted force majeure clause? You know, to be determined. To be determined.
I think if I may weigh in a little bit, John, I think part of this is we don't know how long this is going to last. Obviously, we all hope it doesn't last long. If it lasts, the longer it lasts, unfortunately, the stronger the doctrine of impossibility defense probably becomes. Because if it ends, let's hope, let's end, you know, say there was a miracle and ended next week, you know, a court might say, this is more akin to a snowstorm. I'm not going to let you invalidate a 10-year commercial lease for 2 or 3 weeks. The longer it goes, I think your argument becomes that much stronger. So again, as John pointed out, it's going to be a very fact-specific defense. And I think, as John said, I think the helpful portion of this horrible situation is, this is not something we've ever dealt with. So I think, you know, the courts have literally closed down. You know, the Virginia state court system has, for all intents and purposes, shut down, like the businesses. So it tells you that we are clearly dealing with sort of uncharted territory. And I think there's going to be, my gut is telling me, you're going to find sympathetic ears from judges and juries.
Yeah, exactly. And I'll just add that this also applies to all other contracts. I mean, not just leases. People throughout this country are dealing with obligations where they're not getting the benefit of their bargain. I mean, personally, I have 2 kids in after-school care. The after-school care contract says that if the schools are closed, the after-school care is closed. So I guess I have a semester contract. I'm not sure if I ever even read it, and I'm a lawyer. So do I owe this for April, May, and June? You know, that's a big question. Here's another good topical question. Someone says, Katie says, if there's not a force majeure clause and you are a tenant relying on a common law force majeure impossibility argument, impossibility of operating seems obvious, but how do you make the leap that it is impossible to pay rent? The act of God isn't necessarily preventing them from paying rent, just preventing them from earning money. Do you see any issues making this argument? Yeah, certainly. This is going to be extremely fact dependent. It's going to be really, really circumstantial. I have clients that are government contractors whose business arguably has not and will not be suffered. They've got incredible systems from working remotely. The revenue is going to be coming in. They do have some access to their space. It's their decision not to use the space because of employee safety. For the most part, those tenants, as of now, have not decided to stop paying rent, right? If the example we gave earlier, the restaurant or the bar tenant, where the governor literally ordered you not to be open, yeah, they may have savings to pay that rent, but the one reason they signed that lease, the only use they're allowed to do there is to operate a bar or restaurant. I think they have a very, very strong argument. And again, we have landlords on this call too, I think, and I represent landlord, so does Bob. Landlords are going to have their own defenses to push back here. We don't want to give this advice purely from a tenant perspective, but landlords are also going to have their own recourse up the food chain against their lenders. And again, the stimulus package, which is still being worked out, may or may not have protection for commercial property owners and for commercial tenants.
And if I weigh in, John, there are a couple of questions, but before we get there,
Yeah.
you know, from the landlord perspective, like a restaurant analogy John gave, you may have a landlord very well arguing, well, it's not impossible because you can still do delivery and carry out. And so while we all know that's going to be a substantial hit, I think I mentioned earlier in the call, my brother owns 2 restaurants. You know, he's still doing delivery and carry out, but that represents 5 to 10% of what his normal revenues are. Maybe a clearer example might be a sports club or a gym. You know, if you're closed and you've got a big facility and you've got, weight machines and treadmills and bikes and all of that, you're not going to be doing takeout or delivery of any kind. So, and you may not be able to be open, period. They've closed it. That might be a clearer example of doctrine of possibility, but to John's point, I just want to reiterate, it's going to be incredibly fact specific. Some of the questions we got, one of them is when do you have to assert these defenses? What if tenant has money to pay currently but could run out later? I think John can jump in, but I think you have to give the landlord notice on immersed contracts, and the sooner the better.
I would certainly argue, I would certainly suggest that tenants put the landlord on notice that they're deeming this a force majeure event. Just like the landlord should put their business interruption policies on notice that they're making a claim, even though it's going to get turned down now. Always preserve your rights. And we'll get into this in later slides, but the question about what if you have financials now to make payroll and pay rent for the short term, but long term, it's going to get really, really tough. Definitely, I would prepare your financials. I would try to get some evidence of how this shutdown is impacting you. Most of these decisions are going to be negotiated between landlords and tenants and landlords and lenders outside of court. The landlord doesn't want a good, high quality tenant to go out of business and not be able to operate once this pandemic is over, hopefully sooner rather than later. Who knows, right? Retail environment, it's tough enough as it is for these retail landlords. So I'm seeing a lot of landlords proactively working with their tenants, especially ones that clearly are drastically impacted by this occurrence.
We have another question that says, how does force majeure impact a short-term agreement, such as contracts with venues to host annual conferences or events that need to be canceled? It's a great question. I've got several clients, the firm has several clients that host annual meetings, annual events. Again, it's going to be very fact specific, in the vendor contract, whether it be a hotel contract or a ballroom or the venue that's hosting the event, as to what force majeure is going to be. I think, the first step is have competent legal counsel help you look at the clause, make an analysis of whether the force majeure clause is applicable, or as John says, a doctrine of impossibility, and let them know. Right now, planes aren't flying, hotels are being closed. In Virginia, for example, no more than 10 people are supposed to be together, and it's actually a crime. The governor's executive order makes it a misdemeanor. So it's technically a crime if you violate it. Now, I don't know how often they're going to prosecute any of this, but technically is a crime in the executive order. So I think, contacting the other party of the contract for an event, and putting them on notice, as John says, I think, you need to do as soon as practical. And then got another question, similar. What if we haven't heard anything at all from the landlord? We haven't spoken to them because they haven't even put out a press release. Or what are proactive steps are we seeing from landlords to address these concerns? And I'll let John weigh in. I will say I've seen our lending clients and our commercial landlord clients be proactive in a lot of ways. A lot of them are saying we're going to hit the pause button for 60 or 90 days and make it come on the back end of your lease. They're not forgiving the loans, but essentially forbearance type of situation where they'll agree you don't have to pay rent for some defined period of time. I let John.
Well, yeah, but again, it's very, very fact specific. I would say it's landlord by landlord, fact by fact. Some landlords are getting their lenders to agree to a moratorium where their loan, their mortgage, is postponed, not forgiven, but maybe it's owned as a balloon at the end if the bank's underwriting thinks that's appropriate. I haven't seen a ton of landlords proactively say, hey, tenant, you're off the hook for 90 days. The tenant normally has to ask. And I haven't seen too much of this in the office universe. At least I personally haven't seen it with my clients yet. But on the retail side, it's a whole different animal, especially if you have a restaurant or a bar tenant that you want to be a good tenant for the next 8 years after this pandemic is over. And it's going to be over. This is not the rest of our life. Let's move on to the next slide. Okay, yeah, so we kind of were getting into this impossibility versus force majeure. The force majeure is almost always an actual clause, a provision in a written agreement. And as we said, normally the general rule in life and litigation is if two parties agree on something in a written document that's signed, that's the deal, right? The courts are more likely to not do that in a residential setting. There's a lot of laws protecting residential tenants. There's a lot of laws protecting consumer loans and mortgages. But for a sophisticated business entity tenant and a landlord, or a borrower and a lender that are both businesses, normally the deal's the deal. But if it was that clear, then litigation would be a lot less likely, right? Because everything is not very clear. There's always circumstances that are unforeseen, that are unusual. The language is not always crystal clear. What is the cause of the force majeure event? Is it the virus, or is it the government shutting you down? These are a lot of nuances that creative plaintiff attorneys are going to find loopholes left and right in the cases to come. Let's move to the next slide. Okay, Leah, let's talk about business interruption insurance. This is landlords normally require the tenants to carry this, and landlords almost always carry it themselves. This is insurance that gives the tenant ability to pay rent if they're out of business for some unforeseen interruption. And it gives the landlord the ability to make its mortgage payments and overhead for similar reasons. Again, almost every landlord carries this, most tenants do. Unfortunately for the landlords, a common endorsement that's fairly recent actually expressly excludes coverage for things like viruses. I think it was around 2006, maybe it was after SARS or one of the H1N1 crises. And so that's what's in most policies. But please don't take my word for it. Look at your policy. Some policies are older. Some policies don't have that endorsement. If you need our help, please call us. We're happy to look at this, because that's a big deal, whether or not you have that or not. So the insurance industry so far, not surprisingly, this would bankrupt them in a second. The insurance industry is saying, no, you've got no coverage here. This is not one of the events that was foreseen or covered by your policy. But again, that's not going to be the end of the story. Other arguments can be raised. As we mentioned, what is the real cause of the shutdown? Is it the virus, or is it the government protecting other citizens from harm? Yes, that is also related to the virus, but again, there's going to be creative arguments raised. At the very least, I would suggest, if you have this kind of policy, to at least file a claim. Get the process started. The government could very easily, I don't want to talk politics here too much, but if there's any industry that's too big to fail, it would be the few insurance companies that provide business interruption insurance for half of the country, right? So could there be some scenario in the third or fourth bailout package that backstops this? It wouldn't surprise me. So I would have businesses file claims, at least compile the information they will need to backstop a claim to document their losses. Just giving a few war stories. I know there was already a case filed down in New Orleans. I think it was one of the famous bars on Bourbon Street that wanted a sort of an injunctive declaration that the policy covers this. The policy says you have to have physical damage. Well, is a virus physical damage? It physically does exist, but it's microscopic. So, you know, and then the court was frozen because of the shutdown. So this was never decided. So, you know, so who knows? But I can tell you back after 9/11, there were a ton of creative lawsuits on business interruption insurance where claims were paid. There was one situation where an airport concessions operator asked for coverage because they were shut down, because the government shut down their operation because the airport was closed. The insurance company said, no, you don't have any claim because the closing at the airport was not due to damage from the attack. But they ended up winning. The insured was given their policy money because the court decided that no, the closing was not due to the attack. It was due to the government protecting the business from future attacks. You know, maybe that's a nuance, but that's why litigators are so valuable. Let's move to the next slide. Yeah, as we were mentioning, I certainly think landlords should contact their lenders. You know, we do a lot of work with lenders. Again, this is going to be very much a case-by-case basis. Anecdotally, I've heard stories of lenders giving landlords 90-day moratoriums. Moratorium normally means it's not forgiven, but maybe that 3 months of principal is owed at the end of the term as a balloon. I'm not sure on each deal if the interest is paid now or if the interest is accruing. Who knows? These are all things that are negotiable. But do banks want to suddenly have hundreds of foreclosures and drive down the price of the real estate that is securing their loans? No, they don't want that. Does the government want that? Definitely not. So yeah, that's a very much a moving target that's changing every week. Please feel free to call Bob or call me, and we can give you the latest as we know it. And again, the last thing on the bottom here is, how is the stimulus package going to offer relief? I was trying to read the 1,000-page Senate Act the other day. It's not really incredibly clear in each instance. For example, the loan to small business clients, it was a little unclear to me in the Senate Act what businesses qualify, what sort of obligations are covered by the loan portion that's forgiven. But you know, we're looking at this as soon as that law is passed, and we'll have guidance. And then certainly, how is the government going to help the retail sector and the commercial lending sector?
If I may, John, just to sort of expand upon your comments, yeah, we hope the stimulus package, we all probably hope it gets passed today by the House. We have a team standing by to analyze it as soon as it comes out, because it's going to impact our clients everywhere and probably just about everybody on this webinar. As a free resource, the law firm has a COVID-19 resource link on our website, which is bkk.com. So check it. It's free. There's no charge. We'll be providing updates to it in terms of what the stimulus package is going to be done. We've heard anecdotally that small businesses and how they're going to be defined as a small business under a certain amount of employees, a certain amount of revenue. We'll be getting loans from the SBA that may actually be turned into grants, meaning if you keep your employees employed, the loan will be deemed a grant after a certain period of time. Take that with a grain of salt and an asterisk until we see the final version. That's just a long-winded way of saying stay tuned, stay connected, because this is going to be incredibly important, and we'll try to push out information as fast as we can.
Yeah, and I see a great question from Anonymous here. That would not force majeure only come into play if the retail space is not able to be inhabited? That is, doesn't this mean that unless the government specifically shuts us down, an argument can be made that we can make use of the space even if it isn't safe? Yeah, totally. I want to emphasize again and again, this is incredibly fact specific. It depends on the language in the lease, and it depends on your circumstances. If I was counsel to a landlord and the tenant still had made use of the space, I would be much less likely to advise my client to consider any kind of abatement of rent. But again, there's business reasons that come into play that aren't legal reasons. The relationship with the tenant, maybe they add a month or two to the term at the end, things like that. Maybe the rent is repaid over a period of time. A lot of things can come into play. But for example, I have a client. The other example was an office client that has dozens of spaces across the country where they can still make use of that space. I have another client with 50 plus locations across the country where most of their spaces are in indoor malls where they are shut down. Now these guys are considered an essential retailer under the declarations by most states, but the landlords are shutting them down. So certainly it's a strong argument not to pay rent if your landlord is shutting you down. But even if the landlord doesn't close you down, and even if you're physically allowed to use the space, the CDC and the governors gave strict guidance. They don't want more than 10 people in a location at any one time. What if the kind of store you have routinely has more than 10 people? I mean, you are also obligated as a business to comply with OSHA. OSHA tells you you've got to keep your employees have a safe workplace. So again, this is incredibly complicated. We're not going to touch on every issue in an hour webinar. Some businesses have much different circumstances from other businesses. So I would suggest reading the clause, and if you really have some questions, feel free to give us a call, and we're happy to help you out.
Two quick corrections. Very astute people in the webinar. The House has passed the bill, and apparently it's on its way for President Trump's signature. So the good news will be that we'll be able to look at that and push that content out as soon as possible. And a correction, the website, I misspoke, it's beankinney.com, not BKA. So it's beankinney.com. There's a link right on the main page with a COVID-19 resource link that'll have some of this information we're talking about today, as well as soon as our fellow attorneys can pour through, the 1,000+ page bill and try to make heads or sense of the different provisions and try to push that out information.
Yeah, and also I would advise you to take whatever analysis you see from the media on these bills with a grain of salt. I mean, the only reason I say that is these laws are so complicated. There's so many cross references. I've seen some short little blogs from really credible national publications that are getting the details wrong, at least wrong on the Senate bill, about how they count employees that make up to $100,000 as far as the short-term loan, about the how the forgiveness portion works, how the program is going to be implemented through private banks. So it's so fast moving. Everybody wants to get some sort of a first person to have the scoop, but the devil's going to be in the details, and it's got to be read. So let's move on to the next slide. Yeah, as Bob and I have been saying, the facts matter. What you do matters. Are you office? Are you tenant? What kind of business are you? Are you a government contractor? Are you healthcare? Are you a business that's been shut down by the governor? Has the landlord shut you down? Is it unsafe for your employees to show up? So many different circumstances come into play here. Tenants should consider giving landlords notice of the event. Hey, or asking the landlord, give them notice and say, hey, we're suffering. We request some form of rent abatement, rent suspension. Start the conversation in good faith. Language in a lease matters. Again, I'm a real estate leasing lawyer. We always learn when these things happen after the fact. I'm probably going to pay more attention to force majeure clause in the future than I used to, but I'm telling you, this language is boilerplate. It's really negotiated. So take a look at it. See if pandemics is included, and more importantly, see if rent is expressly excluded from the obligations that you don't have to do. And just, anecdotally, certainly we're hearing reports that some office tenants and many retailers are not paying rent. They're taking affirmative approach. Landlords can't evict for months, and they just need some help to get. So I mean, retailers are probably not in a great spot anyways, and they need some help for cash flow for the short term. Next slide. Okay, questions and thank you.
So thank you all for listening. We answered some of the questions as we go. We have just a couple minutes left. So if you have any questions, we'll try our best. It's pretty hard to give you any kind of detailed advice or questioning. We can't ethically offer you legal advice, but we're happy to do it. If you have an attorney already, I'm sure they're happy to do it. Contact us. This is a very trying time. But the practical piece of advice is, any of the contracts you think you have in question, break it out now if you haven't done so.
Yeah,
and
I see a question on the chat bar where someone says, Gwen says, my lease does not have force majeure included in it. I don't know, Gwen, if you're a tenant or a landlord, but if you don't have force majeure, that would probably mean that there's no forgiveness for these events. So you've got to look outside that clause to the things we talked about: doctrine of impossibility, maybe business interruption insurance, maybe other kind of creative arguments. Pragmatically, again, I mean, every case doesn't need to go to the Supreme Court. Landlords and tenants hopefully have a good relationship. Hopefully they work together for years. Hopefully they want to continue working together for years. The landlord wants the tenant to stay in business, and the tenant needs the landlord to stay in business. They don't want the landlord to get foreclosed. So how this works out is going to be, yes, a lot of involvement from the lawyers and litigation, but hopefully a lot of good faith cooperation between tenants, landlords, and their lenders. And that, again, is, let's see how it shakes out.
I'm happy to answer any questions. I see that apparently Ruth has a question, and Alicia's asking her to type it out. So we're happy to answer your question, Ruth.
Yeah, I can't see who raised their hand, certainly. There's a question, Bob.
Let's see, there's a question. I haven't seen it come up yet.
Oh, it's thank you for this informative call. Well, you're certainly welcome. Again, this has been a incredibly crazy 2 weeks. We're, certainly most worried about people's health, but everyone's also worried about their businesses and how this is all going to shake out. And there's a lot of uncertainty. We're getting calls from tenant clients, landlord clients, what to do. So if you have those concerns, you're certainly not alone. Got a lot of company. And I really think that waiting until, I'm happy people told us that the House passed this act today. hot off the presses during the webinar. It's great. So I think once we get our hands around this act and push out some guidance, be very interested to see how the first stimulus package addresses retail office tenants and landlords, if at all.
Well, if there's no other questions, I appreciate all your time. Maybe one just popped up. I'm trying to...
Yeah, Sylvia asked, can you clarify the comment on the last slide about tenants not paying rent in April? Hey, that's purely anecdotal. I talk to tenants all day long. Many tenants are going to pay rent because they're still operating. They can operate remotely. They have access to their office space. But yes, I have heard from tenants, particularly in the retail sector, who are really struggling. Their business has cratered. They can't operate. They don't have any revenue, and they don't want to lay everyone off. So they, in some cases, are going to notify their landlords and say they don't think that they have to pay rent. And how the landlords respond will be interesting. How it's going from landlord to tenant across the country, I'm sure there's 1,000 different situations going on, then it's very much a case-by-case basis.
I think anecdotally, John and I were talking with some colleagues, after the Great Recession of 2008 and 9, some landlords were very aggressive and sought to evict tenants. Some didn't, some, cooperated. There's, that's outside of the legal rubric of, whether they had a right to do it or not. Some of the ones that were aggressive in evicting, some of them regretted it later because then they had more difficulty, filling the space. I think as John touched upon earlier is, the landlords want good tenants in the space for long term because they pay rent. So how the landlord views this as a temporary blip or something else, it's going to be a case-by-case basis. The other side of the coin is, what are the legal, which we try to touch upon earlier, is, what are the legal, avenues for either side. And again, that's going to be a fact-specific, case-by-case basis.
And as far as how you want to approach this, if you're a tenant or if you're a landlord, do you want to negotiate with your other side just directly, or do you want to have a letter from a counsel? That's totally a stylistic decision, or the comfort you have in understanding the language in the lease and the law. I have some clients who are just deciding to take a lower, less adversarial take and sending an email to the landlord directly or their tenant. Sometimes they want to involve me to review the force majeure clause, help them get their information ready for the business interruption claim, and hopefully, if they qualify for these small business stimulus packages, and to deal with their landlords or tenants directly. So that's very much a question that the business owners need to decide for themselves.
Lastly, there's a question about whether we can make the PowerPoint available. My understanding is Alicia and the Chamber is going to make this available on a YouTube, on the Reston Greater Chamber of Commerce's website or YouTube channel, so it'll be available. The Weasley caveat language we all have to say is, none of this is intended to be legal advice to any individual participant. It's just to kind of provide you with concepts and guidance. Contact us, contact your existing lawyer for specific advice. We're happy to do it. I'm sure they would be happy to do it. The thing I want you to take away from it is this is more issue spotting for you all, things to think about, some general actions to take, and then get specific legal guidance. Don't just take what we said today and take any specific action. We're not representing any of you here specifically, but we just want to provide and push down some general information, to help. Appreciate all your time and listening to us. Someone typed in there, we're all in this together, and that's absolutely true. I hope all of you and your families are doing well and are safe. This is a very trying time for all of us.
Exactly. Well said, Bob. Well said. Thank you so much for hearing us out, and we would certainly love to answer any questions you have after the webinar.
Great. Well, thank you so much, Bob and John, for providing such incredible information so timely. We certainly appreciate it. And as Bob said, as a reminder, we will send out the link with the YouTube video for this, so you can access it again and certainly share it with anyone who missed. And I ask you all to please consider joining us for our next business success webinar on April 1st. We're going to have one about prolonged teleworking, so practical tips for prolonged teleworking. I think we're all, managing through this, but if we're going to be here a little bit longer, Robin Mack from Telework Virginia is going to join us with some great tips. I also want to mention, I know we've been talking a lot about financing and the SBA loans. So April 3rd, we're actually going to have another webinar on the all be at 1 o'clock. We're going to have someone from M&T Bank talk about commercial loans. We'll have someone from FJY Financial kind of try to give some good personal finance advice as we're, watching all our stocks and things like that. They'll try to talk us through that a little bit. And then most importantly, we're going to have a representative from SBA join us as well. Hopefully they're going to have a full-fledged PowerPoint for us, but regardless, we'll have a representative to join us to kind of help us walk through the details of the SBA disaster loans, how to apply, who's available, how long it's going to take, all that good stuff. So that'll be April 3rd. It's a lot of information, and we're going to have more webinars coming your way to try to keep you all informed during this time, and so we can continue engaging with you. So please do check rustinchamber.com. We do have a resources page there, as Bain Kinney does, right there on our homepage. And, it's got health information. It's got resources for businesses. It also has our member restaurants that are still open for delivery and to go. So please make sure to check that out. Otherwise, thank you again all for joining us today. We really appreciate it, and we hope to see you on the next one. Thank you.
Thanks, guys.